In this discussion of the Discussion from Home series, we will be covering the topic of class action suits. Let's first try to understand what a class action suit is with a simple and short story. As you can see, Madhav is frustrated and so are Chinmay, Deepak, Mahesh and Shruti. They are all frustrated because each found a caterpillar inside their respective coffee cups, which they purchased from a cafe that is owned by a company named Hydra Inc. Frustrated and disgusted, they each decide to file a lawsuit against Hydra Inc. with the claim that the cafe was negligent in its service. As a result, the 5 consumers proceed to the court to register individual lawsuits. However, they realize that it would be impractical to file individual lawsuits against a major company like Hydra, as the legal costs for each individual lawsuit may outweigh the damages each would receive if successful in their respective claims. Shruti happens to be a law graduate and recalls the concept of class action suit she learned at law school. Immediately on reaching her office, Shruti makes a phone call and invites the other litigants to her office. She explains that in order to reduce the legal costs and for each litigant to possibly get a reasonable compensation, they may have to collectively file a class action suit against Hydra Inc. To do so, everyone agrees to form a class and unanimously selects Shruti to be the class representative. As a class representative, Shruti is responsible to file the lawsuit on behalf of the class and represent the class at the court. After filing the class action lawsuit, Shruti appears before the court to put forward the class complaint and collated evidence. After hearing the representatives from both sides, the court finds the cafe was negligent in its service and orders Hydra Inc. to pay damages to the class. On receiving the damages, the class members distribute the money amongst themselves and start celebrating. This is a simple example of a consumer class action lawsuit, and we hope it has given you a basic understanding of class action suits.
So let's see what are the class action types that exist in India. How can a class be formed? Under what law? And where can you draw the source of your power as a class? We thought about it and we thought, how exactly can we really classify classes? It's a difficult job. So we clubbed them into 2 parts. One, statutory, that come out of a specific legislation that's been enacted by the Indian Parliament. The second, that come out of the Constitution of India. The inherent virtue of you being a citizen of India can file a class action. So coming back to the statutory powers, first would be a securities class action, which will be filed under the Companies Act. Second is a class action that's filed under the Civil Procedure Code. The third is competition law class action. And the fourth is the consumer protection class action. So under the Constitution of India, the inherent right that's provided to you by the virtue of you being citizen of India is under Article 32 or Article 226 of the Constitution, when you as a public spirited person or a group of people pursue a common public interest cause and go before the court in a representative capacity. So why class actions? Why this topic? Why classes? We're all living under COVID-19 lockdown, social distancing, all these restrictions that come along with. We saw certain cases and instances in which certain country has been sued by a class of people who have taken serious objection to that specific country not containing the spread of coronavirus. Now, that's a legitimate case for class action. They were all interested people who were affected and they wanted some compensation for the wrong committed to them. We've seen such examples in India very, very often, but they don't really classify and come out as class actions. How many of us do remember when Maggie wasn't allowed to be sold? Most of us do take an exception. We couldn't go to the Tapri and eat Maggie. Well, there are more examples of this, and we're going to explore it in the discussion forward. So, look forward. saw in the introduction about different kinds of class actions and also in the animated video, which we hope you really liked and are still here to listen to us. And now we're going to look at what exactly are the types of class actions that exist in India that can be filed and which are actually left unsaid most times. I'm going to look at what securities class actions are under Companies Act 2013 and what consumer class actions are under Consumer Protection Act 2019. Now, both these legislations are quite new, and that's why we want to bring it into more relevance. And it's not really explored too much by the judiciary or, let's say, by the litigants as much. And it becomes more relevant in the present day because there are more consumer disputes that are arising. There are more there are more companies which are more aware of their corporate governance disputes, corporate governance, and generally their own accountability and transparency towards their shareholders. Now, coming to the first part, which is the Companies Act 2013 and the class actions under it, it's really clear that these kind of provisions did not exist under the older law. It's only after, let's say, 50 years that these provisions have come into picture. Nobody's utilized it in the past. You definitely wonder, 2013 was when it was legislated. Why has nobody filed a class action yet? The reason is because in 2016, the provision which provides for class action was came into effect. In 2019 is when the rules were notified, and it's been a year so far, almost. May is that's when it was notified that class action suits have become a reality on paper and not really in practice. So class action suits, let's come back and say, what do they mean? Class action suits means any member of the company holding a certain amount of shares or, let's say, debentures in that company can take to account the company, its management, its directors, and that includes the auditors of the company and anybody he feels is in default and falls under the provision of Section 245 of the Companies Act to the court and ask them for certain specific relief in terms of directions, in terms of what exactly is going wrong in the company, things that they want addressed. Usual grounds for these class actions would be, let's say, mismanagement of the company, misrepresentation on financial records. If a company is performing well otherwise, and suddenly there's a stock drop of the company, we all invest in companies for money, right? And suddenly your money, you look at your stocks and you realize, oh my god, I've lost 100 rupees in a day. So what is it that I didn't know, keeping track of the market, that suddenly came to light and I lost all my money? And you as a shareholder or a class of you shareholders who would come together, qualify above that specific quantum of shares that you should have held in order to go to court, can take your matter to the court, file it, qualify as a class together, identify that yes, me, I hold certain amount of shares in this company, X holds certain amount of shares in the company, and a lot of you together form the qualification for that shareholding that is required to go to court. Now, court's not going to let you come all together in the first instance. The court's going to check how far along do you qualify for that threshold. The court's also going to check what are your intentions. Is that did you actually suffer a loss? Are you actually a shareholder? Did you just invest in the company after the stocks dropped? Or do you just invest in the company so that you can be a part of the class action and then sue the company and get some damages out of it? Now, the good part is that it's a good process for keeping the company accountable, for you to recover your losses if the company had lied to you on papers, if there's no way for you to find out that your money is going to go down, and the company definitely was at fault. This is a good way. But the bad way is some people would definitely be miscreants, file such lawsuits together. The law has contemplated that scenario and it's put down certain amount of compensation in case you file frivolous lawsuits. So that's one part. Why we've not seen these class actions happen? Because none's happened yet and it takes one to file. Second, we think that the jurisprudence is not so developed. In other countries that we've observed class actions rising, that's because class actions have been a part of their corporate governance and corporate scenario for a very long time. In India, we've always seen things take time to function. It takes time for any machinery to start rolling. The corporate governance norms have recently come up, and it's become very important for companies to comply with that, specifically listed companies. Private companies don't still do that. So, as the awareness rises amongst companies. So it's rising amongst institutional shareholders, proxy advisory companies, the ones who tell the minority shareholders how to vote on specific, resolutions.
I think it would also be useful to look into the context as to why Section 245 was included. And here I'm referring to the Satyam case. As ironical as it may sound, a company called Satyam defrauded its shareholders by falsifying financial statements and fabricating numbers. And even though the CEO was arrested for it, what happened was the Indian shareholders had no avenue to get compensated for the defraudment. Uh, on the contrary, however, American shareholders were compensated, and this was because Satyam had issued American depository receipts issued in the New York Stock Exchange, and you had American investors in Satyam filing multiple class action suits against Satyam in the US. While in India there was no such provision, and it highlighted a big anomaly in the Indian legal system, and it was that time that the J.J. Irani Committee, which introduced Section 245 into the 2013 Amendment Act. Also, this reminds me of another very recent case. Actually, this is related to a Chinese company called Luckin Coffee. Now, again, ironically, Luckin Coffee ran out of luck when American shareholders filed multiple class action suits against it on the allegation that it had falsified financial statement and fabricated numbers. Luckin Coffee is claimed to be the Starbucks of China, and in fact, it is the biggest competitor of Starbucks in Asia. So I think in that context, it's actually, like you said, it is a good thing that we have a class action. We can Shareholders can have a class action claim against companies now, and so I just wanted to just include that so that we can have a better context of the thing.
Recently, on that point, in one of the annual general meetings of Reliance, there was a threat made by one of the shareholders based on why exactly the stocks are not performing well, why is the company not performing well, and why are we kept in the dark. And that shareholder specifically stood up and said this to the MD of the company, that Mr. Ambani, that in case I'm not provided the answers to my questions as a shareholder, who the company owes responsibility to, he will pursue actions such as a class action. But that's the last we've heard of it. We did not hear what exactly the company did, what really happened in the matter, and was there a class action ever filed. And the gentleman who really used the provision was a lawyer himself. So, still have an ear.
So one more point which Shruti had highlighted is why it's not come into force. I feel because the shareholders also have an opportunity to go under 241. I think many of them are trying to explore that territory which has already been explored, and there are a lot of case laws on it, as against 245, which is not touched or it's not been explored. I think that's the reason there are no matters even under 245. That's what I feel.
In fact, the remedies are almost identical. I mean, like, because a company is defrauding in some way, is not performing in the right way. That's why you know through Section 245, which is somewhat similar to 241, 242. And in fact, I think one additional remedy is that you can actually file a complaint against consultants, external advisors, etc. under 245, which is absolutely.
I think it's interesting you bring all of these points because we'll just have to see the kind of threshold Indian courts are going to apply to class action suits. And the reason why I say this is because England recently, in November 2019, had a decision on its very first class action judgment, which did not go in favor of the shareholders. And the threshold that the English courts applied was fairly high. So this was a case filed by the shareholders of the Lloyds Bank back for an action back in 2008 that it had taken. The directors had recommended a reverse takeover of a company called HPOS, and the shareholders 6 years later claimed that the recommendation by the directors caused a lot of loss of value to the shareholders and therefore filed a class action against Lloyd's and its former directors. And the English court, very in an orthodox manner, decided that the threshold for bringing such a class action and for bringing allegations against these former directors was fairly high, and the shareholders did not meet that criteria. So long as the directors were able to prove that their actions were reasonable and any director in their position, in the circumstances, could have taken the same decision, then it was a reasonable action which could not be a ground for claiming damages against the former directors or the company for that matter. And another interesting point that the court held, that even if the shareholders were able to prove those claims against the former directors, they will not be able to prove the quantum of loss and the causation that the directors' actions caused loss of value to them. And that was actually a surprising observation by the court. We'll have to see if the case goes up in appeal and what happens. But as of now, this is how it stands in England.
So there are three parts that I gathered out of it. One is the difference in India would be that the threshold will not be on you. Once you've decided and then once you've proved to the court that you're a class itself, then the burden of proof falls on the other side. In the same way as the US, who has to prove what is very important in terms of class action lawsuits. The classes, one of the reasons why class action lawsuits have not developed is one, because classes don't have money usually and big corporations do. Therefore, to prove anything on their own, it requires funding and basically deeper pockets, which bigger companies do and the classes don't. So that's a big impediment as to why class actions haven't come up and why they may not come up unless we really have a provision for the classes to fund themselves, which is a proposal which was provided in one of the newspaper articles by the MCA to have a specific fund dedicated. But unfortunately, that's not come through. One is that part. Second, I'll come back to Mahesh's point also. He said that the reason why people utilize 241 more is because it's available, more tested. And Deepak's point that the remedies are similar, except that you can utilize it against, let's say, auditors or third-party consultants. So in class action, yes, it's definitely wider, but the quantum of and the threshold which the shareholders need is far lower in a class action as compared to the 10% for 241, 242. Definitely 241, 242 have been used by Indian shareholders, but that's only because it's existed for a very, very long time, even before Companies Act 1956 was available. So I think threshold is one important part in oppression mismanagement versus class action itself. The government, the legislature have really tried to come up to encourage class actions. But the biggest impediment that remains so far for its non-utilization is possibly nobody having the funds, means, or let's say guidance to actually utilize this option. Coming to our next topic, which is Consumer Protection Act and the class actions thereunder. You'd be surprised to know that Consumer Protection Act existed for 34 years before it was repealed, reenacted, and class actions were introduced. And that's quite surprising because India has had a lot of consumer class actions, so to say. And the recent one was the Nestle Maggie, which all of us really loved but couldn't have because the production stopped. And that was a class action. There should have been a class action, but that wasn't a class action because it was initiated by the ministry after its own investigation. Now, what happened is these days we hear a lot of consumerism rise in India. But what we fail to realize is that the consumers need quality products, and there are standards laid down by the government, and there are issues that may happen, and personal injury, loss, compensation that may be required. And the mechanism for that was only for a single individual and not many people coming together. Now, as liberalization has come in since 1992, India has developed. India has a lot more economic big giants serving us products in a bulk. For example, now that we get out of the house, we have ready-made everything. Everything consumed by everyone produced in batches may lead to the same problems for a lot of people. Now, all those people need to come together, fight a case against somebody with bigger pockets so that they can get their own piece of justice. That's that idea behind, and to ensure that the government can take a back seat in when it comes to providing justice to people. The Consumer Protection Act provides for a specific facility, forum, and right to the people, consumers who are affected by such actions, such defective products, such defective services, to come forward and take a case against the service provider or the goods provider.
In fact, actually, even the old erstwhile Consumer Protection Act 1986 comprised of class action suits, particularly Section 12, Subclause 1, Subclause C, provided for consumer complaints of one or more persons. But the main difference when compared to the latest 2019 Act was in the older Act, it was largely incumbent on the consumers to organize themselves into class, and courts were required to recognize such a class. But as against the 2019, the latest one, if you look into Section 10 of the Consumer Protection 2019 Act, it formulates a new authority called Central Consumer Protection Authority, which actually enforces consumer rights as a class. In fact, the CCPA, in fact, has the power to initiate class actions, even call for recalls of products, and also promote and protect enforce the consumers' rights in respect to classes. Also, when you see Section 16 of the latest Consumer Protection Act, it vests the power over district magistrate to investigate a consumer complaint. So when you see the difference between the old act and the new act, under the old act, the consumers have to take up their case on their own as a class. Under the new act, the government, the authority steps in and actually investigates the matter and takes up the class's complaint after a complaint is being filed. So that
I just want to ask a question to all of you. Do you hate it when so it's raining and you have to book an Ola or an Uber, and you hate it when there is a price surge of 3 times or 4 times? I mean, have you experienced it before, and have you really thought that it shouldn't be the case?
No, that's true, but it will fall under anti-trust class actions.
No, because it's interesting because there was a class action suit against it. So 2 NGOs and 2 individuals had filed a class action complaint against Uber and Ola for price surge during demand. So I think this was done in 2016, which was eventually dismissed by the Delhi High Court in 2017, stating that Ola and Uber can do so if auto rickshaw drivers can also do so.
That's quite interesting.
So yes, I think, but from the looks of it, a lot of consumers are actually looking into that avenue of class action, and it's going to become popular. I think even when we mentioned about COVID-19 cases, a lot of it are actually consumer class action suits against e-commerce industries or against airline industries. So I think it's just going to get popular eventually.
So one thing which I would want to point out in this Ola and Uber issue is that this class actions can come into force once you use some particular service under the Consumer Protection Act. You have an option not to use it. So I think that will be the major difference, that if you don't want to use it, don't use it. And without using it, don't come up and make such claims against us, because we are in the business of making money, and we are doing so.
You guys think class action arbitrations and consumer disputes can be a commonplace in India as it is in the US?
I think it will depend on what kind of commercial arbitration we're talking about. For example, eBay already has class arbitrations, but the provisions of that specifically bar you from going into class actions as such as a consumer. So maybe the validity of such agreements needs to be tested before Indian courts, and then we can see if it's going to be successful or not. But yes, the question is really relevant because now ODR is very, very popular in India, and these kind of usually entertainment in ODI. So it's definitely going to come up.
And I like the fact that you introduced class action arbitration there, because I'm an ardent supporter of arbitration. In fact, I think class action arbitration could be a classical option for class action suits because of the classical features that arbitration provides. So this could be confidentiality. You have experts who can act as arbitrators, while in courts, what you see is that you may not have an expert in a particular field, but in arbitrations, you could have experts who can deliver an award related to that field in a much quicker and efficient way without any errors. So like Chinmay said, I think even for consumers, class action arbitration could be a major. I think it could be a benefit in India. Like again, Chinmay said, it is very popular in the US, and a lot would depend on what you read on the terms and conditions that you actually have on your screen when you probably take service from Amazon or eBay, or when you download an app from from their website. So, and actually, a lot of them have arbitration clauses in them. So, and yeah, and ODR is definitely an option. So,
I somehow see a lot of difficulties for this to start off in India, for a reason that consolidation of arbitrations as a process itself has not really been introduced in India as frequently as it is in the US or the UK. And therefore, if you look at independent arbitration clauses in your agreements, then to have individual arbitrations first and then to consolidate them is something that is not going to be very easily done in India, unless you have clauses within your arbitration agreements itself which allow for class action and consolidation. That could be the only solution I can think of, at least from an Indian context.
One particular issue which is very consolidated, which has come up as judicial activism, as they call it, is the public interest litigation. So, what do you think? Does it fall under the class action? Is it a part of it, or is it a genesis? What do you think of that?
I think public interest litigation is like one of the oldest mode of class action. Technically, even though it's not a class action suit as such, definitely public interest litigation represents a class for a public cause. Basically, you file public interest litigation under Article 32 in Supreme Court, Article 226 before the High Courts for a public cause, for the welfare of the public as a class. So it can be definitely termed as for the benefit of a class. But we have gone far from what actually was the intention of public interest litigation, which was like 40 years back, when first time public interest litigation was introduced, whereby ardently it was argued for the release of nearly 40,000 under trial prisoners languishing in the jails of Bihar. Now public interest litigations unfortunately misused a lot, and they are more in the term of publicity interest litigations. We have now come across public interest litigations basically for cases like building a great wall of India to be constructed around the entire Indian border, or like repeal all pre-independence laws because Parliament is a hostage to colonial mindset. And such public interest litigations were dismissed at the outset, thankfully, by the courts. So public interest litigation is a great tool definitely for the public cause. In fact, one of the main fundamentals is that there should not be any private interest. There should not be any interest for publicity or anything. It should definitely be for the public cause. In fact, just to give more of a practical overview, when you file a PIL in Chennai High Court, you actually the person who's actually filing the PIL will have to give his income statement, IT return, I mean basically the PAN card details as well, and what income he derives per month or annually, so that in case if it is found to be a frivolous PIL, if the court imposes costs, the particular person should be able to bear it. So
when you talk about class actions and PILs, I think PILs are far broader than talking only about class. We look at it as public interest. Now, public interest can be represented by one person, or let's say the court itself can take a matter public interest. The idea is that public interest litigations are applicable in rem, and class actions, in the sense, are not applicable in rem, but they're only applicable to that specific class which comes before a specific court or a forum. Now, PILs, any decision that comes in a PIL, even if you're not a party to it, you can definitely avail the benefit of it. For example, let's say an environmental law case, dirtying of Ganga River. No class that literally is represented, but yet there is an abstract class, which means citizens of the country who require that specific public interest. So I think this is a distinction between a PIL, which is an administrative, let's say a constitutional mechanism evolved, and a statutory mechanism for which you actually need to have a defined class.
Closest that we come to for class action suits is probably representative suits under the civil procedure rules. Mahesh, what do you have to say about this?
So yes, as what Shruti just mentioned about PILs being action in rem, these representative suits, as initially developed under the Civil Procedure Code, which is like a foundational procedural code for every action which we are talking here, is also developed as action in personam. When we are looking at common cause, or if you're looking at what is the action to be taken in the event if there's a public nuisance, which is under section 91, or if you have a grievance against a public charity which is created for a particular section of society under 92 of the Civil Procedure Code. So what's interesting, which I observed during my entire practice, is that the evolution of the concept, or the dichotomy, as what I would call it as, common cause versus the cause of action. So, but however, so back in the year 1990, in a famous case of housing board case, as they call it famously, in Tamil Nadu, they had settled this position, and it's and it's no more in dispute, that cause of action does not make any difference so long as somebody is trying to pursue a cause of action, a common cause. It's stand corrected, a common cause for a group of people. But here, there's one difference when you're talking about representative suits, is what I realized. Among all actions such as PIL, security actions, or even under the 241 code, or under the Companies Act, where you can get a permission for an exemption for if not meeting the 10% criteria under 244 subclause 2. Here, you have to get permission from the court to institute it. And in the event you institute it, even after the permission is given, and it is at the instance of the plaintiff who's instituting it, should go about and come and issue notice to every single individual who's interested in the case. And the issue here, which I find it personally troubling, is if at all 10 people about, since no number is mentioned about what is the cutoff number which we'll have to be bearing, if at all 10 or 15 people, for an example, come about and say, no, we are not interested in this action against this particular defendant, then the issue is the court is at discretion to reject the entire plaint itself. So that is one cause of concern I have in representative suits, which of course is remedied by multiple specific legislations, as what mentioned by Shruti at the beginning about 245, where there's 5%, 10%, different criteria which is mentioned. And more recently, which is somewhat connected to consumerism, connected to an act of service, as well as deficiency, is with regard to home buyers. That's something, thankfully, by an amendment back in the year 2018, they came up making a home buyer as a financial creditor under the IBC. So, but any which way here, after that, there were multiple litigations which came into an issues. For one person, should the entire project be driven into insolvency? or for one person, should the entire company, which is operating about 10 to 20 projects across India, driven into insolvency? I think that issue was addressed by the legislature, the parliament, initially by having an ordinance, by putting a threshold of 10% of home buyers of that particular project, or 100 people of that particular project, to go against that particular company. But what's interesting here is that many companies, many national law company tribunals, the NCLTs, have admitted cases against all projects, even though if one project people, project home buyers have not been getting their flats on time, they have admitted the case against the entire company, driving them into insolvency, where the other projects which were about to be delivered and other issues are being answered have come to standstill. So I think these are the issues which are still unanswered, and it's developing. There's an issue of reverse CIRP, which is being proposed by NCLAT, which is yet to be tested, with the Supreme Court. I think it would be once the lockdown is over, removed, and we get into it. But again, an issue which should be counting is it was an ordinance which came into place, and now it's an amendment, and there's a stay on that particular ordinance by the Supreme Court. But again, it's for the pending applications, which means they're trying to make it not retroactive but only prospective in nature. We'll only have to see how we are going to look at uh, the the future course of action with regard to the threshold. But yes, I think the representative suits are like the foundational aspects of all class action today, which we are fighting, which the legislature is coming up specifically.
I'm just going to add one point for just a minute, and I'm going to take just a minute for that. One is, you're right, Order 1 Rule 8 actually serves as the foundation for all class actions. One, because I've seen a lot of product liability litigation against big corporations, in which I've been on the side of big corporations, been filed by consumers because they did not trust the Consumer Protection Act earlier to give them the relief they wanted. So Order 1 Rule 8 was their go-to. And secondly, if we remember the Tata Mystery dispute, there as well, because the Companies Act did not really have the provision of class actions notified back then, and the rules were not notified. There was an Order 1 Rule 8 representative action filed by Mr. Mistry, and along with a couple of his shareholder group in the minority, against the Tatas and the directors, asking for certain release. But that was in lieu of the class action they could have filed under the Companies Act. Yes, but they did, and just to add on, they did file a 241, 242, which is oppression mismanagement, on the side under Companies Act.
If I may just add on with regard to representative suits. So I actually noticed Section 91 of the CPC, which empowers two or more persons to file a suit with the permission of the court to seek a declaration or injunction for against public nuisance. And in fact, this is an action which can be brought if no special damage has been caused to such persons who bring the suit. So I'm guessing that this is a more of a substantive right for somebody to file a suit in the district court, and it would be possibly done using Order 1 Rule 8. However, what I wanted to know is that could this be a guise for a public interest litigation which can be filed through the district court rather than going under Article 32 or Article 226 of the Constitution, either to the Supreme Court or the High Court?
So what I feel is that yes, as what Shruti and me did make a point that this was a foundational aspect for all class actions today. So PIL, the reason I think we approach the High Court or the Supreme Court is considering the quicker redressal, and we don't have to aggregate people as what is required under Order 1 Rule 8 Sub Clause 3, or even after getting permission. And even if so, it's probably a quicker process to be adopted by going to the Supreme Court under 32 and High Court under 226. But yes, prior to judicial activism, people could definitely go under Order 1 Rule 8, read with 91, because again, nuisance is a tortious act which you may directly or indirectly be affected. I remember one case which Deepak had filed few years ago, which was about a butcher shop, being in a locality which it should not have been. So so that way, it was filed by somebody not living in that particular locality.
It was filed by an
What
activist
happened?
in the particular area. It was filed by an activist who was living in a nearby area who was not actually affected by the slaughterhouse. So you can file an
What,
order too late, even though if you're not directly affected. But just
so
answering Mark's question, sorry.
what happened in the matter? Did the court accept it?
Yes, they did. We got the relief as well.
Wow.
So just answering Madhav's query, another thing that you should keep in mind is that the rules of evidence are a lot more stringent when you file it under Order 1 Rule 8. The questions of examinations, cross-examination, so many other things comes in when you file a suit, as against filing under Article 226 or Article 32, whereby based on the documents on record or anything that further is being provided by the other side, you can actually summarily rule on that particular matter. So that's another thing. And I'm also happy that Madhav actually mentioned the Tamil Nadu Housing Board case and then went on to go with the home buyer issue, because basically Housing Board, I think, is kind of a nexus that brings between the home buyer dispute and Order 1 Rule 8, because it were the home buyers who actually filed in the Housing Board issue. It were the allottees who actually filed in the representative suit capacity in the Tamil Nadu Housing Board case. And just to clarify as to what the main importance of that particular case is, the difference between cause of action and common cause. So basically, even though different demand notices were issued for different allottees, which meant that different cause of action arose for each and every allottee, the Supreme Court still held that the common cause is the factor there. All the allottees were affected in a similar manner. So that's why they entertained Order 1 Rule 8 in that particular case.
Yeah,
And sorry, go ahead.
no, sorry, just a small clarification for the interest of everyone here and also the viewers. Actually, it was Mahesh who mentioned about representative suits and home buyers, home owners, and not me.
Oh, sorry. I meant.
Watching carefully would know.
So
I'll
another
just add 2 points. Sorry.
little on Order 1 Rule 8 is Competition Act, which also provides for filing a case under Order 1 Rule 8, whereby under Section 53 subclause N subclause 4 of the Competition Act, in case of breach of any of the provisions of the Competition Act, one or more persons who have suffered a loss or damage can make an application after getting the permission of the Competition Appellate Tribunal before the Competition Appellate Tribunal itself, and seek a remedy for loss or damages. So that again will be filed under Order 1 Rule 8. The provision specifies that a complaint under the Competition Act will also be filed in the representative capacity under Order 1 Rule 8 of CPC.
I suppose we might get some clarity from our guest speaker as well.
Yes.
Definitely.
Yes, and we have a guest speaker who Mahesh will be introducing.
Yes. Now that we had a brief discussion, an explanation about PILs and everything about Deepak, I think another important aspect would also be as to what would be the state's reaction to a PIL and other class action. So, to have a view about that particular issue, we have the Additional Advocate General of Government of Karnataka, Mr. Dhyan Chinappa, with us to share his view. One unique aspect, apart from his credentials, which is all over Google, is that he's the youngest senior counsel to be appointed in the state of Karnataka. So, with that short introduction, I would invite Dhyan Chinappa, sir. Hello, sir. Yeah, thank you for joining us. And we are expecting to have a view about what would be the state's responsibility or the state's reaction in case of a PIL, and how is it different from class action and the concept of class action as such. So I would ask Madhav to go ahead with it, the first question.
Sure. Thank you, Mahesh. Uh, just a very general question at the beginning. Could you, in a way, from your experience, differentiate between a public interest litigation and a class action suit?
Madhav, I think India is not alien to class action litigation first. The reason why I'm saying this is because even before the advent of public interest litigation, under the Civil Procedure Code, we always had the concept of a representative suit, where one can sue for many, or so not one, but two or more can sue for everyone, and then initiate a proceeding against either a governmental entity or a private entity, and sue either for damages or for various reliefs. Therefore, if you look at the Indian context always recognized class action litigation. That it was not used too much is, of course, a clear fact which is well within everyone's knowledge. But if you look at Order 1 Rule 8, that is a classic example of a representative suit. And you can sue for anything under the sun. There are procedural safeguards, of course, as to how it should be done. But having complied with those procedural safeguards, you can initiate a class action litigation. I'll give you two more examples actually of class action litigation, which is there in the Civil Procedure Code, but not spoken of much. If you look at Section 91 of the Civil Procedure Code, these are suits against public nuisance. Uh, Again, something which hardly anyone actually looks at all. But these are representative suits which are specific to public nuisance. Then you look at Section 92, you have suits against public charities. Those are very large suits actually, and those are suits which can actually change the course of how a charity works, including replacing members and the like. And of course, if you look at the Companies Act 1956, there was always oppression and mismanagement proceedings, which 10% of the shareholders or a certain number of shareholders could initiate, which would actually benefit the entire cross section of shareholders in a large company, for instance. Uh, Now let's come to public interest litigation. Public interest litigation, of course, is against the state. It's against governmental entities, and I think, though the Supreme Court is said to have invented this as a mechanism to do public good, I think it was always part of our judicial system. It was something which was brought in by the Supreme Court as one means of ensuring that it had the power to ensure public good. So these are representative suits. Ultimately, they are representative action. They are action against governmental entities, governmental bodies, maybe governmental companies as well, which may be doing or carrying out a wrong, which needs to be corrected. And that's what our superior courts, the High Court and the Supreme Court, are empowered to do. So, from Bandhwa Mukti Morcha to maybe even interference in some contractual relationships, there have been public interest litigation which has been there across the country. And as government counsel, we don't actually deal with so many class action litigation in a civil court or anywhere else. Our entire burden is to defend the state when there are public interest litigation. I think those are the largest. And to give you a classic example, the manner in which our High Court has actually been looking at the COVID-19 scenario in Karnataka, and have been issuing various directions to try and protect the interests of migrants, food security, disaster management. All classic examples of how the judiciary has actually monitored and ensured that the state takes care of the needs of people. So, I think it's really fora in class action litigation which makes the difference. Public interest litigation is the most classic and best known example of class action litigation.
Thank you, sir.
Yeah. So one question which always bothers a lot of us when we are coming on the private side and we file a PIL. What would you think would be the course of action of a state against the corporations in the event of any breach of, like, say, the LG polymer issue which happened in Vizag? So, what would be the responsibility of a state at that point of time as a class action? This is a continuation question from the PIL.
Mahesh, it's quite possible that there are two kinds of class action which we start. One is against the corporation which has actually been responsible for the leakage of the gas. That could be one class action litigation. The other class action litigation would possibly also involve the state not taking steps to ensure that all remedial or protective measures which ought to have been taken was not taken. Now, if that comes out, that could be a larger class action litigation, a public law remedy to espouse a private right, where people may come forward to say that the state also owes a responsibility to ensure that people are taken care of or people are compensated for the losses that have been caused. Now, even if it had been, let's say, a private entity which was managing the entire shore, still it's possible that the state did not take into consideration various safety measures that should have been taken by that private corporation, leading therefore to this situation. So you can't entirely exclude the possibility that the state could also get sued in a scenario of that kind. And that will be a public law remedy and not a private law remedy. So a private law remedy, of course, will require you to go file a suit, maybe make the state a party, the corporation a party, and then proceed through a private law remedy. But in those cases as well, since it is strict liability, you must and can expect a public law remedy for damages as well, and then the state will have to defend it. And given the fact that it's strict in terms of liability, I don't think the state or the corporation will really have any defense given the leakage. So those are, public interest litigation are very difficult to defend because if really it's a cause which is important, then the state must find a way to comply with it. And you will notice that in most public interest litigation, which are really public interest, and as opposed to politically motivated or publicity motivated, you will find that the state has on most occasions found ways and means to try and comply with directions of the court or with the problems that have been pointed out by the petitioners.
So, just
But
from what you've just said, do you see class action suits being misused by the public at large? To arm twist government or private entities to get theater blockbuster damages?
The damages, you see, let me give you an example here. When it comes to actually damages, there are two remedies, and courts have always accepted that in larger cases, you could always permit a certain amount of money to be awarded by the court as a public law remedy, and then leave it to the parties to go through a private law remedy. So the court accepts the fact that yes, there is a wrong, but we need to protect a person by giving him some damages, not what he's entitled to, but a small portion of it. And then say quantification is something which we can't do without evidence. The public law remedy, which requires you to need evidence, and therefore you need to go to a civil court and establish a liability. But the difficulties of those are people now have to pay court fee, and people have to then bear the costs of litigation, which a public law remedy is much cheaper to do. So those are risks and difficulties which we must accept are going to be part of issues of this kind, unless you come within the consumer legislation where the court fee is lower. But if you have to go to a civil court, then the costs are a bit concern.
Just taking on your previous question, what are the remedies that you suggest or the role of the state in determining and facilitating the classes to go for statutory class actions, the purpose of which is actually to enable litigants exhaust statutory remedies against private entities which have wronged them? Because what we understand from our discussion earlier is public interest is not at large in all class actions.
Yeah, you're right. Now, take for instance, there is a gas leakage in a private entity, which is why I said there are two kinds of scenarios which could arise. One is, has the state taken all care to ensure it doesn't happen? That is one part of the state responsibility. The other is the loss suffered by one particular section of people. That particular section, either two or more, or a larger section, have to get together and sue that corporation. That I'm saying is the typical way in which it would work. But in a situation where, as you remember, the Union Carbide case, the state took upon itself the responsibility as parents patriae to sue on behalf of the people. That is how they went to the US courts, sued. So it is the government of India which went to the US court. of course, the action got rejected on the principle of foreign non-convenience, and it came back, and ultimately it resulted in a settlement. But that is a classic example of the state taking over the responsibility from the people and so. Uh, well, it may not happen in all cases. In most cases, it does not. And in why that we don't know. I mean, people may have to sue in order to recover damages, or the state may impose on the corporation some liability so that they then make payment because the liability is strict. But these are common and easier such scenarios. There could be larger situations where laborers are not paid the wages because the corporation is going through difficulty. How should they then sue? Should they go to an industrial court? Should they file a petition in the court? Again, then there are questions of whether the respondent is a state actor, because otherwise you can't initiate writ jurisdiction. So ultimately, if you have to go to civil court, you need to then remember you have to bear a cost, and that cost will not go away.
Just to give a practical perspective to this discussion, sir, just based on your experience, since you're also the AAG, I don't think there's anyone better to actually speak on this. Any one or more interesting class action from your experience that you can elaborate so that it'll be benefit for all who are listening to this conversation?
See, I think what I've been actually doing now, I've been appearing for the government in all these cases relating to COVID. And I'll give you a couple of examples. Initially, the entire focus was on food, because all of them were in Karnataka, and there was suddenly a lockdown and no one could step out. So there were a host of public interest litigations which were filed, which were all taken up together to ensure that food reaches everybody. And that was a huge exercise. The government had to ensure Anganwadi workers, had to ensure Paura Karmikas, had to ensure that workers in various sites throughout the state got rations. So, and the Labour Department had to now work on establishing canteens, which were supplying almost 3 lakh uh, kits of food every day across the state. Suddenly, all of a sudden, you had to scale up operations to such an extent, and so many people had to be involved, and the court is monitoring you. That's it, one part of it. Then the lockdown lifted. Now came the situation of migrant workers wanting to go back. Then came the question of cost. Who's going to bear the cost? So this is also interesting because initially migrants, there were about 3 lakh migrants who had to go. Then the state decided that they'll bear the cost of the migrants going back. When that decision was taken, in less than 2 days, that number went to 7 lakhs. So today, all of a sudden, you have a situation where you have to deal with 7 lakh migrant workers who want to go back. You need to organize trains, you need to pay for it. And the state says you'll only pay till 31st of May. What will happen after that? You can't transport everybody before that. So, these are two classic examples which I'm saying in the same case, in a span of about 1.5 months, you've seen from food to transport. And everyone wants to go back to their respective houses. There are many, of course. I mean, if you're on the government side, you only see how the government gets wrapped for everything that it doesn't do.
One thing which was a part of a discussion also was that would cost become a major factor when it comes to class action, and what do you think about it?
See, if it is a public cause and it's a real public cause, then the costs are not too much because you have one fora where you go, you come to the High Court, and you don't have to then pay on court fees and things like that. It's a very nominal amount of court fees, and typically the High Court will take charge of that litigation. But if you have to now sue for damages, then you must necessarily go to a civil court. And if you go to a civil court, then the largest cost at the initial stage is not just the cost of lawyers, expensive lawyers like yourselves, but also to pay the court fee, which is huge, and it's ad valorem. And imagine if there are a huge number of people who are entitled to money, and you have to make a calculation on that basis. The cost could be astronomical, especially by people who can't afford. And at that point in time, it becomes extremely difficult to try and fund it. And you see, a third-party funding litigation is called a champertus agreement. And from what I know, at least in UK, it isn't something which is found to be against public policy, and therefore Champerty's maintenance and Champerty, as they call it, are regarded invalid agreements. There is no specific provision actually in Indian law which bars Champerty's agreements, except when it is with lawyers. So a lawyer can't be party to a proceeding where he'll bear the cost and then get a portion of the proceeds at the very end. But it's not unknown that you could have a Champerty's contract or a funding contract for litigation with a third party who may have a right to recover something out of it. But the larger question is, will it fall foul of Section 23 of the Contract Act? Because Section 23 provides for public policy, and whether it is opposed to public policy or not becomes a big question mark. As a matter of fact, there's one judgment of the Supreme Court which I think we should all take a look at, which involved a sum of rupees 75,000, which just prior to independence, when the Nawab of Hyderabad passed away, there were various claimants. And one of the claimants had actually been funded by someone, and he had given 75,000 rupees to prosecute that litigation. This went up the civil court when ultimately the person who was financed succeeded. A suit was filed saying, I'm entitled to this money. That contract was actually struck down by the civil court as being opposed to public policy. But it did go up to the Supreme Court. Supreme Court actually didn't go too much into the question of Champerty. It seemed like they accepted that you could have an agreement funding litigation. But in that case, they found that litigation involved an interest in the ultimate suit first. And secondly, it also had a provision which said that he will involve himself with various authorities of the government to try and ensure a favorable outcome. So they said that such a contract was opposed to public policy, violative of Section 23 of the Contract Act, and struck it down. And therefore, they said he could not even recover the money he had paid. Forget getting the benefit of the litigation. You see, the contract itself is opposed to public policy. So, in a grand situation, the Nawab not only got the money, took it, and he succeeded on that basis. So they kept everything and never had to pay back the 75,000 which he got as well. So I have some doubts about funding litigation, and I don't know if Indian courts are ready to accept funding of litigation. Well, I personally think it's high time they come out with rules and regulations to do it. It's better to do it and ensure that people follow a set of rules than for people to start doing it on the hide it away and try to mask it through something else. And I think it should be done for lawyers as well. So lawyers are all going to be commercial today. So if lawyers are going to bear the cost of the entire litigation, you should, of course, trust in their honesty and integrity, of course, in ensuring that the litigation doesn't get spoiled because they have an interest in it. And that is the ultimate objective. Lawyers shouldn't have an interest because then they may do something to ensure that they recover their money faster. That's ultimately the logic behind it. So given that, you must ensure a lot of independence to the client. But I think you can regulate it. If you regulate it, there's nothing wrong with it. And if you regulate it, at least lawyers will know what they can do or can't do. Today, you allow and let people remain in some kind of confusion on what is to be done. The older lawyers like me wouldn't approve of it at all. But I think with a lot of law firms working and who are willing to bear the cost of such litigation, I think it's good because clients don't have to bear that cost, and that cost could be very high. And you have someone who's fighting that litigation right through, and ultimately coming out with some kind of a result which is in the larger interest of a larger community. There's nothing wrong personally. I mean, these are all, and I remember actually in that Supreme Court judgment, they say public policy can evolve over time. And what is public policy in the 70s or 80s or 90s is no longer public policy, as we understand. So, classic example is 377 of the Indian Penal Code, of how things change over time. So I think, we should look at something like that. Nothing wrong with doing that. That's my view.
Any questions?
I just have a very general question, and I'm sure the answer is going to be subjective for everybody. If you were appearing for a class, maybe in a shareholders dispute or a consumer dispute, would you approach such a proceeding differently as a senior advocate representing them as opposed to any other proceeding? Is there a different kind of process as a lawyer you would want to undertake?
Not really. I don't see why it should be. See, the difficulty is in a representative proceeding is you need to ensure that not merely the people who come to instruct you, but the interests of everyone else is taken care of very carefully. It is not just enough to take care of those who come and brief you, because they themselves are representing a larger group of people. So it's a little more responsibility, I think. Well, in 90% of shareholder disputes don't really involve anyone else other than the people who've come to court. So typically, I don't see them as greater or more difficult class action litigation. But insofar as consumer litigation, and if it does take off, class action, I think those will be more, will bear a greater responsibility on the lawyer, because you have to be careful to ensure that the benefits of every order percolates to people who actually deserve it. And that becomes a little more difficult. But I think ultimately, as lawyers, we have to handle a case on the basis of the facts and the law opinion.
I just have one last question, and that connects both class action lawsuits, specifically securities class action lawsuits, and third party funding. In all the jurisdictions that they've come up, including Australia, Canada, and the US, both of them have evolved hand in hand. Do you see the development of third party funding regulated by state or otherwise in terms of legislation, and class actions, which specifically securities class actions, which actually have rules in place now, developing together?
Well, why not? I think, I think the Bar Council has to first come up with a set of rules and regulations for this to first take care of lawyers and how they handle cases of this kind. But I think the state also must come up with legislation to take care of such class action litigation. And it is perfectly justifiable to ensure that someone who wants to fight a large litigation requires a lot of money. So you need to be able to defend and offend, and with sufficient money, just like a large corporation can find within its might the ability to defend. So you need good lawyers, you need good law firms, you need domain experts to come, and you can't just, and therefore that becomes a difficult situation for people who can't afford costs. If you have to, if a state is, if a company is going to fight multiple appeals right up to the Supreme Court on every single order that a court passes, for an individual, it becomes absolutely difficult to find good lawyers, to ensure that there are lawyers at every stage and they fight the litigation. And that cost is too, I think, restrictive to ensure a just cause is taken to its logical conclusion. So yeah, some kind of funding may not be a bad idea at all.
No further questions. We can conclude.
Great.
Thanks a lot.
Thank you so much, sir. I think
Thank you.
this was.
Thank you, sir, for coming.